Initially in our petition, we filed petition against INEC, NNPP, and Excellency Abba Yusuf. These are the three respondents we instituted an action against. So, on Saturday we closed our cases. So we started 2 witnesses precisely. And we tendered series of documents ranging from Beaver's report, Beaver's machine, from EC8A 1 and from EC40G, and some other forms emanating from INEC. And almost all the documents we tendered were emanated from INEC, and INEC certified all of them, and we tendered them before the court, and the court admitted all the documents we tendered. So it's now for the INEC to come and defend itself in respect of the allegation we made in our petition, in respect of our claim we made in our petition, and we established through our witnesses and the document. Beautifully today, when the matter was called often, the INEC lawyers intimated the court that they are not calling any witness, they closed their case. So the matter was adjourned to tomorrow for the other parties to open their defense. For the INEC, they didn't call any witness, they closed their case. So all our claim in law, when you didn't call witness, when you didn't tender any document to counter what the petitioner or what the plaintiff presented before the court, you know what it means in law. Well, the issue of reviewing the evidence, the issue of reviewing the testimonies given by the witnesses and the document tendered is that of the court, not of any lawyer. So that decision is for the court to make at the final stage. That is when the court is writing its judgment, when the court is handing down its decision. It doesn't lie in a lawyer just to retire to his office or anywhere to review the case. That evaluation is for the court to do, not for a lawyer. And all the documents we tendered, as I rightly pointed out, were certified through copy from the INEC. They emanated from the INEC. So it doesn't lie in a lawyer to say this document is not from INEC. Even if it lies in a lawyer, it's for them now to come and bring witness and deny the document we produce. And to make evaluation and reach a decision, as you said, they said today, it doesn't lie in them. It's for the tribunal to make that. Well, we are ready. We are fully ready to cross-examine all the witnesses that they will bring before the tribunal. We are ready, fully ready to cross-examine them. So also, these 2 pronouncements is for the tribunal to make, because if a lawyer said it's an academic exercise, he reached a decision, which is not his duty, is duty of the court. If a lawyer said it's dead on arrival, so also this is a decision, it's for the court to make. We are bad as lawyers, ethically, to reach a decision when the matter is pending before the court. So it's very wrong for them to even say that. But be it as it may, our petition, as I always say, we have 3 solid grounds. And our ground, especially the first one, is on issue of qualification. And that issue of qualification hinges on the membership. And we all know in law, before you contest any election, you must be a member of that political party. In fact, it is against that background, in the new Electoral Act 2022, the provision, that is section 75, made it clear that all political parties shall submit its register to INEC not later than 30 days to the conduct of primary election. And this provision is not made for fun. It's made in order to know the members of the political parties before they commence primary election. That is the wisdom for this provision. And we applied and obtained the certified true copy of register of NNPP. And his name, The name of their candidate then, His Excellency Abba Yusuf now, his name is not in that register which we collected from INEC certified true copy. That is number one. Number two, the issue of valid vote, that they didn't win the election with majority of valid vote. We were successfully in producing the ballot papers, over 170 ballot papers, certified one by INEC. Some were not signed, some were not stamped, some contain no date. And the law requires all this to be contained in the ballot paper before it become valid. And we tendered all before the tribunal. Our last ground is the issue of this INEC returning officer. He ought to declare the election inconclusive on the ground that there was margin of lead of 120 something vote, while there were cancellation of over 170 votes from EC40G, the form filled by INEC official, the form filled by all the agents sent to respective polling unit wards and the local government by INEC to report to INEC, and they reported to INEC, and instead of declaring the election inconclusive, they went ahead and declared the result of the election, despite the fact that in the same election, on the same day, the election of 14 to 15 state constituency were declared inconclusive on the ground that there were violence and disruption because of that cancellation. Which register? Because there were so many registered tender. Which one? So that I will answer you well. And if the lawyer that you said, he said the register was shown to him and he showed his name, had it been he told you which register? Because we tendered certified true copy from INEC. They tender register from the party, original register from Gwale local government. Of course, in that register which they tendered, his name is there. But in the register we tendered, which emanated from INEC, which the law, section 75 of the electoral law, require the parties, political parties, to submit to INEC. In that register, they didn't even show him that register to warrant showing his name in the register, knowing fully that his name is not in that register, which emanated from INEC. So a takaice wannan yanayin kamar yadda kowa ya sani dama tun kara da muka shigar mun shigar da kara mun kara INEC, hukumar zaɓe da jam'iyyar NNPP da shi mai girma gwamnan Kano Abba Yusuf. Wannan mutane uku muka yi kara, kuma kowa mun faɗi dalilin yin karanmu da kuma abin da muke nema a kan shi da kuma abin da muke cewa ya yi ba daidai ba, kowanne daga cikinsu. So kaga mun gama gabatar da shaidunmu kusan 32, kuma mun gabatar da takardu masu dama da yawa, tun daga bibas mashin, bibas report, forms da ake cikewa na akwati da na mazaɓu da na ƙananan hukumomi duka mun gabatar a gaban kotu da sauran takardu duk da suke tabbatar da ƙorafe-ƙorafen da muka yi. Amma a yau alhamdulillah INEC suka ce sun rufe ba sai sun kira shaida ba. So kaga duk abin da muka faɗa a kansu da duk bayanan da muka yi a kansu da duk takardun da muka gabatar a kansu na kurakurai da suka yi, kaga abu ne da ya zama karɓaɓɓe kenan, tunda ba ma wanda ya suka akai ko kuma ba wanda ya kawo wani abu da ya saba da abin da muka ce. Dama abin da ake bukata a shaida in ya gama bayarwa, idan wanda aka yi kara ya zo ya kawo bayanan da suke sabanin haka ko ya kawo abin da ya gazgata wancan bayanin da muka yi fiye da haka, to su ba su ko ɗaya ba. Su kaga sai dai mu ƙara godewa Allah sosai. An ɗaga zuwa gobe domin jam'iyya su kawo shaidunsu.
Well, you know, today is one of the dates scheduled for the first respondent, that is INEC, to call their witnesses. You know, ordinarily they have 4 days for them to present their case. But today, they informed the court that after they have reviewed the case of the petitioner so far, they discovered that there was no need for them to call any witness. This is because none of the witnesses so far presented by the petitioners has even testified to the allegation made by the petitioners. And therefore, they felt that it is just a waste of time. As we are saying, the case of the petitioners is just an academic exercise. None of their witnesses so far testify before the court, and none of the the witness evidence would be reliable before the court. If you could remember, the petitioners called 32 witnesses. 30 out of them are polling agents, and that 30 polling agents were able to show to the court that they are not party agents sent by the APC. They themselves testified before the court that they are not within the list of the agents sent by APC to act as an agent during the governorship election in Kano State. Therefore, whatever they said, because it is only an agent in the polling unit set by his party that can come and testify before the court. Therefore, all that 30 agents that they have called, their evidence are useless, cannot be relied upon by the tribunal. That is why the INEC feel that there was any case presented by the petitioners, and therefore decided to close their own case. That is what exactly happened, not the insinuation that were making by the APC people that INEC come and say that the election was not done in accordance with the law. That is not the case. You know, they were saying a lot of things to just play the gallery and to generate followers from the Facebook and what have you. I don't know, I'm afraid why they were sending a wrong message, a fake news to the public, because this is not what happened in the court. What happened, as I'm telling you, is that INEC, after reviewing its case, closed its case without calling evidence. Not that they have said that the election was marred with any irregularity, not at all. So that was exactly what happened. You know, the next thing is that the second respondent was given from tomorrow to see whether if they will call witness or not. The second respondent too has 4 days to present their own case. So we informed the court that we will review as well and see whether if we will call. I am emphasizing, I'm telling you that these witnesses that they have called, even if the court agree with them, cannot in any way tamper with the outcome of the election, because you see, we have 50 people in each polling unit, which means that the registered of voters in each polling unit is 50. They have called 30 witnesses, which means that they only call, they were able to call people to testify in only 1,500 in a places where 1,500 polling unit PBC voters card were collected, and the margin of lead is over 135,000. So it's obvious that even if the witnesses have testified and the court agree with their testimony, it will not change the outcome of the election. So we will review and see the possibility of bringing up with our witness or the possibility of not. But from tomorrow or within this 4 days, we will make decision, God willing. That is not the case, and that was not correct. You see, whatever before the court, you see, even we used to even inform the court that any application or case brought before the court is dead on arrival, and we ask the court to dismiss it. So what we are saying is that you, as a lawyers, we know the case. We were in this game. We know what they have presented. They know that they presented a dead arrival case. And I am telling you, by God's grace, within short possible time, you will hear the decision of the tribunal that this case is an academic exercise for 3 reasons or a lot of reasons. Now, this petition was presented by the APC. Their prayers was that somebody who is not a party to the case be declared as a winner of the election. In law, you can't do that the moment you brought an application seeking for an order against non-existent party, several decisions of the court say to testify to the fact that and make a decision that that case is an academic exercise. So what we are saying is the decision of the court and it's the decision of the Supreme Court as well, because in the case of CPC against INEC, if you could remember, that was exactly what happened when Buhari decided not to join in an election petition filed by CPC. The Supreme Court said that the fact that Buhari, who is a candidate of the party, was not joined in the petition, the petition is just an academic exercise. And that was what we are saying. This petition is an academic exercise and waste of time. So, alhamdulillah, kamar yadda ya faru su yau dama an sa ne don in suna da shaida su kawo. To sun duba, sun bincika, sun ga cewa idan aka duba adadin shaidun da su wanda suke kara suka kawo, ba shaidar da za ta yi tasiri. Hasali ma ba wata shaida da suka gabatar wacce za ta gamsar, don haka suka ga ba za su bata wa kansu lokaci ba. Domin shi a shari'a wajibin shi wanda yake kara ne ya zo ya tabbatar a gaban kotu allegation din da yake. Abinda doka take dauka idan INEC ta ba da sakamakon zaɓe ta ce ga wanda ya ci, wannan abin da ta faɗa daidai ne. Kai da kace ba daidai ba ne, kai ne za ka kawo shaidu su tabbatar, wanda kuma su shaidunsu babu ɗaya da ya zo ya iya tabbatar da komai a gaban kotu. Hasali ma shaidun nan sun tabbatar da cewa kawai 'yan busy bodies ne, kutse suka yi domin babu sunansu a cikin waɗanda APC ta tura su zama agent ɗinta. Sun tabbatar da kansu, star witness ɗinsu da suka kirawo Rabiu Suleiman Bichi ya tabbatar da haka. Saboda haka tun daga kan shaida na 1 zuwa shaida na 30 duka a shari'a ba su da wani amfani. So saboda haka idan ka duba ka gani za ka ga me yasa INEC za ta ɓata kanta lokaci ta kirawo wani shaida bayan su da suke kara ba su iya gabatar da abin da zai gamsar da kotu ba. Shi wayannan abubuwa ne wanda mu da muke harkar shari'a aka yawanci za ka ga lauyoyi sun fi gane me ake faɗa, domin aikinka ne ka tabbatar, in baka tabbatar ba wanda zai zo ya maka aikinka. It's only idan ka iya tabbatar da wani allegation mai ƙarfi shine wanda yake da kariya zai zo ya clarify. To tun da baka yi ba wanda ba buƙatar a zo a kawo maka wani shaida a clarify wani abu. Ba in effect abinda muke cewa babu abin da suka iya gabatarwa, kamar yadda kullum muke faɗa cewa wasa kwakwalwa ne da wasan kwaikwayo dama, don haka ba abin da kotu za ta yi, ina tabbatar maka Allah da sai dai ta kori wannan petition din.